First of all, I would like to thank all of you for coming to this session devoted to sanctions. I would like to thank the panelists. I will introduce them briefly so that you know them. We have Joseph Brand, partner, Square Pattern Box, Washington. Mr. Pabadze, Deputy Secretary General, Human Rights Committee, Republic of Iran. Mr. Bismus, Poitiers, France. Mr. Dolgov, Ministry of Foreign Affairs, Department on Human Rights. Mr. Klishets, Federal Assembly on Constitutional Law and Constitutional Structure. We have also Mr. Tuvenon, France. Mr. Chizhov, permanent representative to Brussels. Mr. Nagen from China. We have a lot of presentations. We try to make them brief so that you have time to ask questions. I would like to give the floor to Mr. Brandt, since the US sanctions are the sanctions which are familiar to even the kids in Russia. Mr. Brandt, you have the floor.
Thank you, Khristofor. Khristofor says that we will have each of the panelists will have 6 or 7 minutes to speak, and after that we will engage in a question and answer program, which I think we'll find more interesting than our own speeches. I would like, if I could, to get my PowerPoint put up.
Валентина, вы могли бы, да, включить сейчас для Джо его презентацию?
First of all, I must apologize for a definitional issue. In the United States, when we say unilateral sanctions, we mean sanctions imposed by a single state. I'm told that in the European parlance, that means unilateral sanctions means sanctions imposed that are not sanctioned by or allowed by the United Nations. We're here to talk about the law pertaining to sanctions. I realize it's a highly charged political issue. We can also talk about politics. But first I would like to describe in the United States how sanctions are imposed. They may be imposed by the President of the United States under authority granted to him by 42 different statutes, which are described in the PowerPoint you see before you, or they may be imposed by the Congress of the United States by legislation. In either case, whether imposed by the President or by the Congress, they have the effect of law. You see here that the United States, since the beginning of World War I, which was the first time economic sanctions were imposed by the West, they had been imposed in antiquity by the Greeks. The United States first imposed sanctions in World War I against the Axis powers. And from that time to the present time, the United States has imposed sanctions 120 times. Most of these have been multilateral sanctions, but not all of them have been. And of the 120 sanctions that have been imposed by the United States, most have been imposed in the past 15 years. Now let's see. The sanctions administrator in the United States is the United States Department of Treasury's Office of Foreign Assets Control, called OFAC. It has the jurisdiction to impose sanctions. And here we have who is the subject of U.S. economic sanctions. We have the next slide, please. Who is subject to U.S. economic sanctions? The OFAC regulations apply by law to U.S. persons, and U.S. persons are defined here to mean, I'm not sure I can read that, U.S. citizens or residents in the United States, companies organized under the laws of the United States, their foreign branches and offices, and of most importance, persons physically present in the United States. Next slide, please. Next. Non-U.S. persons can be subject to sanctions in the United States by a process called specially designated nationals. And the effect of being a specially designated national, or an SDN, is threefold. First, it means that all property of the SDN subject to that's possessed in the United States can be seized. Because the person is subject to the United States laws, no U.S. person can engage in business with that person. Now, the effect of the sanctions laws basically mean we are sanctioning the United States persons from engaging in certain conduct. We are not sanctioning foreign parties, except in very narrow cases. May I have the next slide, please? This is the GATT Article 21 that's been imposed by, I think, 9 times in history. The effect of this is to say that the WTO cannot impose its will on countries engaging in sanctions if they use the definition of emergency as provided in Article 21. Khristofor, I think that's exhausted my time, so I'll pass on to our colleague from Iran.
Thank you very much, Joe. Я тогда попрошу господина Казема Гариба Абади.
Mr. Abadi, Deputy Secretary General of the Supreme Council on Human Rights of Republic of Iran. Iran has a lot of experience combating sanctions and living under sanctions, so you have the floor.
First of all, I want to refer that there are 2 categories of sanctions. International sanctions that are imposed by the Security Council in accordance with Chapter 7, Article 41, Chapter 7 of the United Nations Charter, and the second are unilateral sanctions. What I mean by unilateral sanctions are the sanctions that are imposed out of the context of the Security Council, whether they are imposed by individual states or by a collective or group of states. For example, if the EU imposing sanctions on some specific countries or target countries, those are interpreted as unilateral sanctions, not international sanctions, because those are beyond the Security Council mandate and also beyond the Charter of the United Nations. Through 1990 to 2010, actually, there was a survey that more than 900 resolutions, sanction resolutions that were imposed by the Security Council have been analyzed, that more than 15 mandatory sanctions have been imposed only on African continent, and the rest actually 5 on Middle East and 4 on Europe, 2 on Asia, and 1 actually on on American continent. So it shows that Security Council, while imposing sanctions, focused on African continent and focusing on one continent and ignoring the other regions, while we are suffering from instability throughout the world in many sensitive regions, shows that the sanctions that are imposed by the Security Council, although it is mandated by the Charter of the United Nations, but are mostly and on the majority basis are imposed on the political considerations rather than legal and technical considerations and observance and obedience of the Charter of the United Nations. But when it comes to unilateral sanctions, so the first point is that even the Security Council is authorized to impose sanctions, it has its own limitations. The limitations originates and arises from the charter provisions and rather than, for example, other instruments. So the charter imposes restrictions. While the Security Council is restricted to impose sanctions, that one restriction actually is to take into account the other provisions like the development of the countries, the humanitarian purposes, and also the purposes and the principles of the United Nations, that the third purpose in accordance with Chapter 1 of the Charter of the United Nations actually is to respect also human rights and humanitarian aspects. But I want to stress that when it comes to unilateral sanctions, they are totally in contradiction with international law. They are totally in contradiction. And you know that there are a group of countries and some individual countries imposing unilateral sanctions on a variety of reasons that they deem it is necessary for their own national interest or possibly in the interest of the international community. But one thing that is important is that the countries, even the Security Council organization, it wants to impose sanctions, whether they can ignore the human rights issue or not. So I want to say that no, it's not possible. When you refer to the International Covenant on Political and Civil Rights in Article 4, Paragraph 2, it includes also non-derogable rights, such as right to life, such as prohibition of slavery, prohibition of torture. So it means that even when you want to impose sanctions, even the Security Council, so they have to take into consideration some limitations and restrictions. But when it comes to unilateral sanctions, unfortunately, the human rights is ignored. So having access to food is one of the rights of the people throughout the world. Through the sanctions, so they target the people, ordinary people in target countries. They face limitations to have access to right to food, actually. Although the resolutions, either unilateral or international resolutions on sanctions imposed by the Security Council, include some clauses actually in the name of, for example, not to impose sanctions on food or medicine, but practically speaking, it is not the case. The people have in the target countries, they have problem to have access to medicine and food. Why? Because simultaneously there are financial sanctions in place. So the clauses are there in the resolutions or in the decisions of sanctions, but it's not possible actually to pay the money to get medicine and food from other countries. This is one issue. The second issue is that actually the other issue that shall not be neglected in the unilateral sanctions is the extraterritoriality nature of the sanctions. In the world, in the international community, only one state, only one country imposing extraterritoriality sanctions, that named United States of America, that not only imposes sanctions on its nationals or companies or individuals or persons, but imposes sanctions on other countries, persons, and individuals and companies. That this is beyond international law, unfortunately, because it engages and it intervenes and interferes in the jurisdiction of the countries. Jurisdiction is the very well-known and well-defined term in international law and shall be respected by all countries, both through the secondary sanctions or the sanctions that are imposed extraterritoriality. So this important principle of international law also is breached. When it comes to human rights also, some scholars and lawyers, they are of the view that the unilateral sanctions, because of the effects and consequences they have on ordinary people, they can be seen as a methods and weapons of conventional war. So this is very dramatic analysis actually. That why? Because it has its own consequences on people. It will destroy the infrastructure in the countries. So it's a method of war, conventional war. So I agree with this analysis and with this finding by many scholars internationally. So this is one issue. The second, actually, when it comes to the human rights aspects and consequences of unilateral sanctions, either the sanctions are imposed by the Security Council or unilaterally imposed, they are not in favor of human rights, and they have their own consequences on human rights of the people. Even Security Council nowadays talks regarding the targeted sanctions. Even targeted sanctions also, they violate the human rights, basic human rights of the people in target countries. The sanctions will destroy the infrastructure of the countries and will bring suffering for the ordinary people. And also they will increase the suffering of the civilians in target countries. So they will have restrictions on access to the food, to health, to medicine, and also will increase the malnutrition, will increase the mortality rate. And these are, the surveys have been conducted in some target states that are under sanctions actually in this regard, that these are the consequences when it comes to the human rights issue. And also the impact and consequences of sanctions over the rate of employment and unemployment also shall not be ignored. The other consequences of the sanctions over the human rights issues is, for example, some sanctions have direct impact. For example, when you impose travel ban on people, so you interfere in the rights of freedom of travel of the people. This is in contradiction with the international law and also some human rights instruments. Some sanctions also are in violation of privacy rights of the people. For example, when you put the names of the people in the list of sanctions, so you will expose them to the international community without there being any kind of facility or opportunity for them to defend themselves, to reject the accusations against themselves. So you will put in danger their credibility, and also the privacy is violated here in this case. And as I have told, the lack of legal due course is very important in unilateral sanctions. There is no legal due course because the people, as I have told, they don't have the opportunity to defend themselves and to reject. There is no appeal, for example, for the sanctions when the people, the companies, they are receiving the sanctions. Also, the sanctions intervenes in the right of self-determination of the people. So when there are, for example, emergency situations, the countries, target countries receiving sanctions, so the situation is deteriorated. So it also has its own consequences on the self-determination in the elections, in every aspect related to the self-determination due to the emergency situations that are created by the unilateral sanctions. Also, sanctions interferes in the right of development of the countries. It was referred actually to the international trade regime and also its relation with the unilateral sanctions. You know that when it comes, for example, to the WTO and also the Article 21 of the of GATT, referring to the exceptional security exception that is used by the countries, that there are cases against them where they are imposing unilateral sanctions against the countries. Note that by 13 March 2015, more than 491 complaints have been registered to the dispute settlement body of the WTO. And by 13 February 2015, more than 199 decisions have been made. So it shows that actually the dispute settlement body of the WTO can be seen as one of the mechanisms to bring a case toward the WTO dispute settlement body against the countries that they are imposing sanctions. There has been many cases in the past regarding Nicaragua, regarding Cuba, against the United States of America. Also, they are resorting to the security exception, but in some cases, the dispute settlement body actually rejected the idea that if you want to resort to the security exception, what about the provisions of GATT? What about the provisions of WTO and the rights of the target states? So this is one issue. The next point actually is regarding the countermeasures. I want to make a reference to this issue. Some countries, they impose unilateral sanctions under countermeasures. You know that there is a difference between countermeasures and sanctions, legally speaking. Sanctions, they have their own place in international law. Sanctions are imposed only by the Security Council under Chapter 7, Article 41 of the United Nations Charter. But when it comes to unilateral sanctions, you can justify them under the countermeasures, not the sanctions, because sanctions are imposed internationally, not unilaterally. I will sum up in 1 minute, please. So you see that countermeasures, when it comes, for example, to Iranian case, Iran nuclear issue, so some countries, they are of the view that we have imposed sanctions against Iran's nuclear program, that Iran wants to acquire nuclear weapon. So under the countermeasures, they are imposing sanctions, while Iran has never violated its obligations under the Non-Proliferation Treaty. Iran has not produced nuclear weapon, and also you know that under countermeasures, the countries that they impose sanctions, they have to be affected directly through the violation of the obligations by the target states. While if we suppose that Iran violated its obligations under NPT, has not violated and affected the security or the rights of other countries, what shall we do regarding the unilateral sanctions? One is the WTO exception. I have told the dispute settlement body can be one solution. The second is the national courts. Iran persons and individuals and also the companies, they have taken the opportunity, they have referred to national courts in the European Union countries, they have brought cases, and also they have won the cases in some circumstances and in some issues. The next one is the General Court of the European Union also, because European Union also are imposing sanctions. Also Iranian companies, they have won some cases, they have brought the cases before the General Court of the European Union, and the other mechanism can be ICJ, International Court of Justice, if there is any competence or jurisdiction or bilateral consent to refer the cases before the ICJ. These are some solutions that the countries that are under sanction, they can resort to these legal and also judicial processes to follow up the sanctions. Thank you very much.
Спасибо большое, господин.
Thank you so much, Mr. Abadi. And now I give the floor to Mr. Bismuth, Professor Regis Bismuth from France, please.
Thank you very much. And first of all, I would like to apologize for my French accent, which constitutes a unilateral sanction on the audience. Next slide, please. Thank you very much. I will first try to define extraterritorial sanction. An extraterritorial sanction is a sanction imposed by a sanctioning state against a person having the nationality of and located in a third country, in a third state, for carrying out economic activities with a target state. So, for instance, the sanction imposed against BNP Paribas by the United States for activities conducted in Iran with Iran businesses or with Cuba. The goal of extraterritorial sanction is to target the trade between the target state and third states. So this is why we call them extraterritorial sanctions. We have mainly two examples of extraterritorial sanctions in history. The first example of extraterritorial sanction is the boycott of Israel by the Arab League, because all businesses worldwide that did business with Israel were blacklisted by Arab League countries. And of course, the second example of extraterritorial sanction is the sanctions that are imposed by the United States against mostly Iran, Cuba, North Korea a little bit, Sudan a little bit, and Russia since December 18, 2014, following the adoption of the Ukraine Freedom Support Act that could target non-US financial institutions that do business with special designated entities. So we must keep in mind that there is a dichotomy, a distinction between the sanctionable activities that are extraterritorial and the sanctions that are applied in the territory of a state, of a sanctioning state. So for instance, it could be a trade restriction, it could be restriction regarding government procurement, and so it could be a penalty, just like BNP Paribas, and so on and so forth. Next slide, please. Thank you. I'm just going to present 3 devices through which the US extends the application of its laws abroad. The first of them has been already presented by the first speaker. It is equity ownership. Branches, but most importantly, subsidiaries of US companies abroad, controlled by US corporations, are subject to some US sanction laws. For instance, if you'd like to hear a funny example, an hotel in Oslo that was owned and controlled by the group Hilton had to reject a booking from a Cuba delegation in Oslo. The second device of extraterritoriality refers to the situation through which a person in a third country is prohibited from re-exporting goods and technologies of US origin without the permission of US authorities. It was notably the case in a very well-known 1982 Euro-Siberian gas pipeline project, because the US prohibited Europeans from re-exporting gas pipeline technology to the USSR for the construction of this project. From an international law standpoint, this type of extraterritorial legislation cannot be covered by the nationality principle under international law, and this was said basically by the European communities at the time through a memorandum that was drafted by the EC in 1982, which said goods and technology do not have any nationality, and there are no non-rules under international law for using goods or technology situated abroad as a basis of establishing jurisdiction over the persons controlling them. And then we have the third device of US extraterritoriality. It is the US dollar. The idea is the following: any transaction that involves and that uses the US financial system is subject to US jurisdiction. It is pretty clear when you read the documents related to the sanctions targeting BNP Paribas in 2014 and 2015. And what we said about goods and technology could be said as well for the currency. The currency does not have any nationality. If we consider that the currency and that the clearing system of a state is an appropriate basis of jurisdiction in international law, it will confer to the US dollar, that is a worldwide used currency, a de facto universal jurisdiction. So from an international law standpoint, it is not, I would say, acceptable. So the question is now, how should we, or how could we, combat this extraterritorial application of sanction laws? Next slide, please. We have 2 options: counteracting through blocking statutes. It was notably the case in 1996, following the adoption of D'Amato, Kennedy, and Helms-Burton legislation in the US targeting Iran, Libya, and Cuba. The EU adopting a blocking statute, basically prohibiting EU persons from complying with US sanctions. But the problem is that blocking statutes are unilateral responses to unilateral sanctions, and it does not, of course, solve completely the issue. So another option that could be viable and effective is the WTO dispute settlement body, because many sanctions that are extraterritorial cannot be justified, or first of all could constitute violation of several WTO law agreement, WTO agreement provisions in the GATT, for services, in the GPA, the General Agreement on the Agreement on Public Procurement. But of course, it requires the willingness of states, of WTO member states, to act and to initiate proceedings before WTO courts. And we saw that in 1996, the EU reacted against extraterritorial sanctions that were adopted by the US. It was not the case in 2014, following the BNP Paribas case. A member of the EU Parliament questioned the EU Commission about the legality of US measures against BNP Paribas and asked whether or not the EU were willing to initiate proceedings against the US before the WTO. And this is the reply of the EU Commission, the former EU Commission, in September 2014. Sanctions are a foreign policy instrument applied also by the EU. The Commission does not comment on proceedings to which it is not a party. So it is not likely that the EU will try to combat US extraterritoriality through the WTO. Thank you very much.
Thank you very much, Reggie. Very accurate. Спасибо, Режи.
Thank you, Regie. And now I'd like to give the floor to Andrei Klishets, chairman of the Federation Council Committee on Constitutional Law and State, Doctor of Law, Professor. Well, I hope that now we'll hear some interesting position regarding the measures that our country is trying to take regarding sanctions. Thank you, organizers. I'm really grateful that I was invited to this session. With great attention, I listened to our colleagues, and I am not an expert on sanctions, and I heard this professional analysis of the situation, and I felt that I was attending the meeting, which is not so much dedicated to law, but so far very cautiously it was said that sanctions are more political or economic, and only in part these are legal measures, especially that there are not too many legal grounds for sanctions. This is Security Council jurisdiction, so on, and I'm not going to repeat what was said here, but I would like to draw attention to the following. Most of these decisions regarding sanctions, of course, touch upon the interests not just of the governments and private companies, but also of certain individuals and parties. Quite often we use this term rule of law state, and as a professor of constitutional law I do know the substance and the history of this notion. Would like to draw attention the highly important aspect, because when our Western partners criticize certain processes in Russia, they often talk about the necessity of having efficient institutions of the rule of law state. What is rule of law as such? And there is some perfect model saying that this is the country where rights and liberties are not violated, which is impossible, because no matter how well developed the country is, no matter how well developed all the institutions are, the rights and liberties are violated. Quite often the government is not to blame, but people, subjects of legal relations, they understand the boundaries of their rights in a different way. And a rule of law, from my point of view, is the state with efficient mechanisms of restoration of violated rights. This is the main feature of the rule of law state, and only this state which is going to restore the rights sufficiently could be considered real rule of law state. And now let's look at the sanctions per se. Are there effective mechanisms of restoration of violated rights of the persons that are affected by limitations that we call sanctions. And if those limitations are against the people that are residents, the companies. Our first speaker mentioned that there are different types, could be American companies, could be American citizens, but I believe that certain legal mechanisms of the protection of interests do exist. But when we apply this extraterritoriality term, we get all that out of the legal field. It ceases being legal because regarding such types of sanctions, no matter what we say, we don't have efficient mechanisms of restoration of violated rights. And the motivations when the sanctions are adopted is political or economic. And often we don't know real motives for such decisions. Let's look at the sanctions regarding Russian political activities, also situation in Ukraine. And they have sanctions against me. It was written there that my speeches in the Russian parliament destroy government structure of Ukraine. When I asked my American friends, my lawyer friends, I say, well, people who actually conducted the coup in Ukraine, they destroyed government system. Yes, but they say we don't have to impose sanctions against them. So such sanctions are not part of legitimate fabric. This is the issue of politics, economics, realpolitik, and using this type of pressure. At the same time, I'd like to say that in order to to put some citizen, politician, businessman, or regular citizen who teaches in the university, in order not to issue a visa, you don't have to impose sanctions. Every country has the right to decide whether this person is welcome in the country or not. I asked the European Union, what is freezing assets? What is it all about? I'm not an expert in civil law. My field is constitutional law. I said, do they have freezing assets provision? As the person who worked as chairman of the board of directors of major banks in Russia, I know how many documents you have to bring to court, and then how many court documents you have to bring to the bank to stop transactions for the client. Is European Union different? And I'm not sure, but in the future it could affect our legal systems. The government could make any decision. It's dangerous. It can make decision regarding any person, any assets, any rights and liberties of this person, not providing mechanisms of restoration of violated rights. This is what de facto is happening when extraterritorial sanctions are used regarding companies or individuals. That's why the question is a very political question, and when something is political, and when we're talking about the issue of something being reasonable, legal issues get to the background. It's not necessary, as I understand, to upground such decisions, because I'm not an international law expert, but this is the act of aggression regarding the country, and the country has the right to choose the mechanisms of protection. For example, use reciprocity principle, establish certain volumes and the time limits in order to protect the markets and the citizens. That's why I believe that it's extremely important to discuss legal grounds for certain sanctions. And I agree with my colleagues who said that, well, that vicious practice was so widespread in the 20th century because the system of international relations was based on the most important principle of balancing interests, and a lot of mechanisms were created also in the framework of the United Nations, GATT and WTO, in order to use the mechanism of interests and getting some judicial or quasi-judicial procedures and get mutually acceptable solutions, bypassing, avoiding one-sided actions that could be dangerous, especially regarding human rights. I am aware of this concept that was mentioned by our colleagues from Iran regarding American currency, dollars. Well, it's a paradox for me. It's not... I'm not sure that American legislation could be applied like this regarding American currency. Nobody here says that everybody who uses Russian gas is in Russian jurisdiction. It sounds quite funny, and that's why if you want to provide your illegitimate position using some funny explanations, it's possible, but it's much better to do it using political rallies. But lawyers, maybe American lawyers are ready to discuss it as legal matters, I'm not sure. But lawyers don't really take such reasons seriously. All one-sided sanctions, all similar measures, quite clearly, this is an attempt on the sovereignty of the country. And this country has the right to use all possible and probable mechanisms. First of all, mechanisms of the United Nations and other international groups in order to convey its position to the partners, explain the motivation, and then the response measures could be taken to protect national interests and the sovereignty of the sanctioned country. Thank you. I have to apologize. I have to go to another event. I am sorry. Don't. I do respect all of you, but I have to go. Dear guests, I just have to leave now. So while Andrei is still here, I'm going to say that now we're giving the floor to Richard Blakely. He's a talented young barrister from Brickford Chambers from London. He's a brilliant sanctions expert. He has great experience working in court, also regarding sanctions. Richard, you have the floor.
I'm going to be talking about legal challenges to EU sanctions measures. And in doing so, it's important to keep in mind two different distinctions at the outset. The first is the difference between derivative and autonomous EU sanctions. Derivative sanctions are sanctions imposed by the United Nations that then flow down into the EU legal order, more or less automatically. The second type, autonomous EU sanctions, is where the EU goes further, and often much further, than the UN in the types and breadth of the measures it imposes, and that they are the unilateral sanctions as they've been termed today. There's another distinction that needs to be kept in mind between so-called smart or targeted sanctions, which are asset freezes imposed on companies and individuals, and bans on travel imposed on individuals, on the one hand, and on the other, industry or sector-specific sanctions, which are more akin to trade or economic sanctions. Now, I'm going to be talking about EU autonomous sanctions, and in particular the smart sanctions, or so-called smart sanctions, imposed on individuals by way of an asset freeze. Now, the legal framework for the sanctions measures starts with a CFSP decision of the European Council. That is a common foreign and security policy decision that sets out, broadly speaking, the sanctions that are being imposed. That is binding on the member states of the European Union only, and so it is followed with an implementing regulation that is binding on everybody. Now, to impose the sanctions requires unanimity on the part of the Council. So if a single member state opposes a sanctions measure, it will not pass, although abstentions don't affect unanimity for these purposes. So in practice, lots of member states abstain, so far as we can tell, and it is a certain handful of member states that are driving the sanctions regimes forward. The decision and regulation will contain a statement of reasons in respect of each individual or entity on whom an asset freeze is imposed, explaining why the Council has decided that particular individual should be subject to sanctions. Now, the statement of reasons is one of the most inadequate parts of the sanctions regime, in that they are usually 1, 2, 3 lines long and very opaque, very general. Challenges to smart sanctions are brought by way of an application for annulment under Article 263 of the Treaty on the Functioning of the European Union. That article gives individuals who are directly and individually concerned with a decision the right to challenge it before the General Court, which is the first instance court in the European Union. That requirement of standing is very clearly met when talking about asset freezes. It is less clearly met when talking about sector-specific sanctions and trade-type sanctions. And that question hasn't been decided yet. I've got a case next month in Luxembourg on behalf of an Iranian bank where we are challenging the sanctions imposed on the Iranian financial sector, and whether that challenge can be brought at all is going to be a live issue that is for the court to decide. Now, the court has jurisdiction to hear these disputes under Article 2752 of the treaty. That creates an exception because the court usually has no jurisdiction in respect of common foreign and security policy matters. They are left to the executive branch of the EU, also essentially the political branch of the EU, and are outside of the court's normal jurisdiction. There is a narrow exception for sanctions measures that have effect on individuals and entities. Turning to the grounds of challenge, they are, broadly speaking, can be put into 3 groups. The first is a manifest error of assessment on the part of the Council. The second are procedural grounds, and the third are human rights and proportionality type grounds. Starting with manifest error of assessment, this is really the winning ground. This is the ground that has been successful for applicants before the EU courts, and that includes the larger Iranian banks, individuals, across a lot of the sanctions measures. Essentially, it's an argument that the Council got it wrong, or that it doesn't have any evidence for the position it's put forward. I've mentioned some cases there, but I think in the interest of time, I'll focus just on the Fullman case. Now, when I first started doing these cases about 7 years ago, it wasn't decided who bore the burden of proof or whether the Council was required to actually provide any evidence for the allegations it made in the Statement of Reasons. It may seem like a fairly elementary proposition of fairness that the accuser should have to present some evidence, but when we started all this, we simply didn't know whether the court would be so deferential that the Council could get by on what it called the inherent plausibility of the reasons. And the Council persistently argued that it did not have to present any evidence, that the evidence was secret, and that it would be contrary to the good administration of the system if it had to bring evidence to court. And in one of my cases, the Council argued that the evidence was so secret that it had not seen it. Only the proposing member state Just gives you an idea of how this system works behind the scenes, or doesn't work. The Foreman case, which I mentioned towards the bottom of the slide, which was decided at first instance in 2012 and upheld on appeal in 2014, is the first time that it was clearly established that the burden of proof was on the council, that it must prove at least one of the allegations it makes that's sufficient to satisfy the requirements for imposing an asset freeze, and that it's not for the sanctioned person or entity to have to disprove the allegation made or to prove a negative. So in Foreman's case, it was accused of involvement in construction of some sort or another in a nuclear facility in Iran. It simply said, no, we didn't. No, we weren't. We deny this. Prove it. And the council couldn't. And one of the reasons the council couldn't is because it doesn't keep any evidence on its file. It keeps nothing. It has nothing. So it comes to court and argues it shouldn't have to produce anything. So following Foreman, the pattern of the cases has been, as I say at the bottom of the slide, just to deny everything. And so far, that has worked in a large number of cases. The Melat, Sadarat, and Tijarat cases that are on the slide, which are all cases that I've acted in, that's precisely what we've done in the end. And they have all been successful at first instance. Melat and Sadarat are now on appeal. Turning to procedural grounds have also been successful in a qualified sense. They've been successful, but they lead to Pyrrhic victories because the council can simply rectify its procedural mistake. So the council is obliged to give adequate reasons, it's obliged to supply the evidence and material it relies upon, and it's obliged to consider any observations that the sanctioned person might make. If it doesn't do it, that is a ground for annulment. But even if you win, the council can simply add you back to the lists and correct or attempt to correct his mistake, and you need to go back to court. And that's a very lengthy process in the European Union. It's 2 years to get a judgment from the General Court. If it goes on appeal, it's a further 2 years. And even if you win at first instance, the sanctions remain in place pending an appeal. So the council, in effect, has a free pass at 4 years of sanctions until there'll be a final determination against it. And that is one of the real problems with the system, is the lack of any interim measures or any relief you can get in the meantime. Turning to human rights and proportionality grounds, there have been some limited human rights type arguments that have succeeded. They tend to be fair trial, due process type arguments as protected by Article 6 of the European Convention. So they're very much bound up with the procedural challenges and suffer from the same flaw that the Council can simply correct its mistake. The Court has generally been dismissive of human rights challenges, and there have been, at least to my knowledge, no successful applications for annulment on substantive human rights grounds. The most commonly invoked rights when dealing with asset freezes, perhaps unsurprisingly, are the rights to property, protected by Article 1 of the First Protocol to the European Convention and Article 17 of the EU Charter, and freedom to trade and conduct a business, as protected by Article 16 of the EU Charter. Now, it's easy to see how an asset freeze impairs these rights. They are not absolute rights, and they're subject to qualifications, and the Court has consistently taken the line that the foreign policy aim, whether it be putting pressure on Iran because of its nuclear program, putting pressure on the Assad regime in Syria, that aim trumps whatever harm may be caused to an individual or entity's personal rights. So the case at the bottom of the slide there, the EIH case, that's a case concerning a German bank, which is, because all its assets are in the EU, all its businesses within the EU, it has been effectively shut down by the sanctions. It's just it's a skeleton organization now with a handful of staff who are simply processing old trades as they run their course. In that case, the court said didn't matter. Although the fundamental right was entirely impaired, the foreign policy aim was more important. Just to finish, to talk about some of the other rights that might be engaged, The Akras case is a case that I did that it quite starkly illustrates the court's approach. It was a right-to-life case. Dr. Tarif Akras was the claimant, and he was a Syrian national who was a sort of prominent local businessman and figurehead. After he was designated by the EU Council, his designation and the accusation that he was aligned with the Assad regime was big news in Syria. It ran round the clock on Al Jazeera. And in the immediate aftermath, he was subject to a series of attacks, a car bombing, death threats, and assassination attempts on his family. We went to the EU courts to try and get interim measures on the basis of this, and were refused on the basis that the court thought no proper link had been established. By the time the substantive application was heard, the court weighed the rights in the balance, but again decided the foreign policy aim was more important. I've been told my time is up very politely, so we'll finish just by saying invocation of the right to private and family life has fared no better. There's been no successful challenge on Article 8 grounds, but we've started to see that you can claim damages for harm to your reputation, and a recent case, the Safa Niku case, shows that damages are available and may be available in terms of financial losses where the sanctions were unlawfully imposed. But it's a very long and very uncertain process. Thank you.
Richard, thank you very much. Я бы хотел передать теперь...
Thank you very much. Now I'd like to give the floor to Mr. Dolgov, representative of the Ministry of Foreign Affairs, Department on Human Rights. Thank you very much. Thank you for invitation. So this topic is quite extensive. We've talked a lot about the legal aspects, and I fully agree with Alexei Ivanovich. He focused on the political aspects. In my opinion, this is a key aspect. As far as the international legal aspects are concerned, yes, indeed, we are talking about the fact that unilateral sanctions and the current practice conducted by the United States is beyond the legal sphere, is not legal, especially in the terms of extraterritorial aspects. And the UN General Assembly also has said that with respect to the human sanction, that it violates the international law. It's just a recommendation, of course, but still this is the position of a majority of the international community or UN member states. Of course, we will never find the direct mentioning in the UN Charter that the unilateral sanctions are not legal, but if you read carefully the UN Charter, then you will find some stipulation that say directly that indeed no actions of restrictive nature should not be conducted to the detriment of the UN resolutions. There is a number of provisions saying that, but the problem is not in this regard, but rather the problem is in the purely political aspects, and I would add geopolitical aspects as well. It's quite clear that measures that are taken by the United States with respect to Iran for many years and with respect to other countries, recently Russia, then this is just a continuation of the servicing US geopolitical and economic interests. The allies, the US allies are mobilized to continue the same pattern, Before me, previous speakers said about European Union sanctions, but let's have a fair view. Of course, we can challenge these sanctions in the European courts, and one of the speakers mentioned that you can challenge these sanctions if they are of economic nature and they contradict the WTO principles or guidelines. Of course, you can challenge them in the framework of WTO. That's the right thing, but of course, we don't see many cases of challenging these sanctions, especially on the part of the European Union, because there is a political team or political orders from Washington and all EU measures or sanctions. This is just a confirmation of the political will of the United States. They contradict directly to the economic interests of the many European countries, European business. Our Foreign Minister Lavrov conducted recently a meeting with the French business community, and everyone confirmed that France is suffering quite enormously because of these sanctions, and they just would like to see the lifting of the sanctions as soon as possible, but they doubt, because US policy is focusing on inflicting as much damage as possible on the Russian Federation, and at the same time they try to mitigate or constrain the geopolitical interest of the European countries as well, and their economic potential and economic relations with Russia. So this is a multi-tier policy with a well-pronounced extraterritorial element, and of course we should always remember that US measures undermine very much the resolution of the Security Council of the United Nations, and our Iranian colleague has just said about this. I worked for many years in the United Nations, and I participated in adoption of many resolutions on related to sanctions, and all unilateral US sanctions inflicting or very detrimental to the UN resolutions. So they practically focusing on the same thing, but in fact they undermine the well-balanced resolutions of the United Nations. So in other words, the threat is not only in the fact that these measures are taken unilaterally, which is a bad thing, but another bad thing is that the geopolitical agenda starts forming the legal reality. We see a lot of voices, not here, but in other places, an assessment in the foreign mass media who try to justify US sanctions against Russia, European sanctions against Russia. They try to provide quasi-arguments to support this idea, but this is a sad thing, because it's a well-financed attempt to form some kind of legitimacy or provide a legal basis for the policy of unilateral sanctions. This is quite a dangerous thing, because the international law doesn't provide for a clear definition of the unilateral sanctions, which are or which should be considered as the direct violation of the international law. I mentioned the UN resolutions, but we understand the difference between the UN resolutions and some imperative international legal acts. So in fact, in parallel with the conduct of the unilateral sanctions conducted by the United States, So the United States at the same time are trying to legitimize these attempts, which is a quite dangerous thing. And I would like to agree with the speakers who spoke about countermeasures. And in conclusion, I would like to mention one more measure, countermeasure. We need to mobilize the international community or public opinion in order to have some political pressure on the US circles, US government, to stop this practice of unilateral sanctions. Of course, this is a very difficult work, which takes some time. We work very hard on that, and we feel that public opinion in the world is developing in this area. But without these political countermeasures, I believe we can hardly cope with these problems, because the national court system shows that European countries in particular, I'm not saying about the United States, they are saying that the political component is always present in the activities of the court. Despite what our Western partners are trying to say, blaming Russia that we have a very political element, or our court system is highly politicized or politically motivated. So this is just a reality for any country. Thank you very much. Thank you very much, Konstantin Konstantinovich. I would like to give the floor to Mr. Tavenan, Professor of International Law, Nanterre La Défense from Paris. You have the floor.
Good afternoon, ladies and gentlemen. My topic is written on the board. I will talk about sanctions inflicted on members of the parliament acting as such. And the question is it lawful? Okay, so to begin with, let me remind you that we are in a so-called smart sanctions era. For sure, economic sanctions inflicted by a state to another state is common ground since a long time, since like 2,000 years. But during the 90s, this practice became something like a day-to-day practice, so much that observers depicted the 90s as the sanctions decade. But during the 90s, the international community went a little bit too far in inflicting very harsh sanctions to Iraq. And maybe you will remind that because of this sanction regime on Iraq, all the population was hit, and it was felt as a humanitarian disaster. As a reaction to that, the doctrine of smart sanctions emerged. When it comes to sanctions inflicted to individuals under this doctrine, the sanctions are supposed to hit directly those responsible for the acts triggering the sanctions, and therefore sparing innocent people. But the problem is to determine exactly what are the people that should be hit. And there comes the question of the categories of targeted individual persons. In the first place, when you look at the blacklists, you will see that obviously sanctions can hit people supposed to be terrorists or related to terrorists, maybe people related to governments having had some bad activities. You could find militaries, policemen, businessmen, people really involved in the actions that are contested at the international level. But nowadays, maybe because these sanctions are not really efficient, nowadays you can find in the blacklist academics, scientists, relatives of sanctions persons like the wife, the son of people sanctioned. Now, to a certain extent, I could be sanctioned maybe by the European Union because I work also, like my colleague, for Iranian companies before the European Court. And so I help Iran in a certain way. Maybe I could be sanctioned. I don't know, because nowadays we have another category of sanctioned people, which are the members of parliaments acting as such. So my neighbor talked about that a little bit before he left, but on the blacklist nowadays you will find sometimes members of parliaments that are sanctioned. You have two situations, in fact. A first situation where the member of the parliament will be sanctioned for its behavior outside the parliament. This is not my topic, really, but you will find this in the Zimbabwe regime, for example. You have another situation which concerns Russia, in which the sanction is imposed because of the activity of the person as a member of the Duma. So the sanction is decided because this person proposed to pass a law or and voted in favor of the adoption of a law. So here is the question: is this practice lawful? And here maybe I will try to bring you in a little legal reasoning. So at first sight, your first reaction would be to say, well, obviously this practice runs against a basic principle, which is, I'm waiting for the picture, which is the principle of non-liability of members of parliaments for votes cast and opinions expressed. So this principle is important for me because it originates in the French Revolution, and you know that French people are very proud of this. And so nowadays this principle of non-liability of members of the parliaments is widespread through the world in each and every democracy. And the European Court of Human Rights said recently in 2014 that this immunity, because they call it an immunity, protects parliamentarians from external interference. So the sanctions we're talking about is an external interference, obviously, but the problem is, if you have a little reflection with me, is that this principle belongs to domestic systems. It is not belonging at first sight to the international legal system. So the question we have to put is, can we find some kind of equivalent rule in the international law? So I propose three arguments in this regard. Sorry. Yes. I propose three avenues, three discussion, three arguments in this sense. First, it could be contended that insofar as the rule does exist as a domestic law in every state in which a parliament has been established, in other words, in every civilized nation, it should be seen as a general principle of law. And as you may know, Article 38 of the Statute of the International Court of Justice states that general principles of law recognized by civilized nations are sources of international rules, sources of international law. This is the first argument. Second argument, it is a very simple one. We could argue that inflicting a sanction to a foreign member of a foreign parliament is an interference in a foreign state's internal affairs. Obviously, when a government interferes in what the parliament does, it's an interference. If a foreign government does that, it's also an interference. And interference in internal affairs is prohibited by international law. So this is the second argument. And the third argument is related to the right to freedom of opinion. One could think about the right of freedom of opinion or expression, which is recognized in international law, in European law, and in European Union's law. Indeed, by voting or proposing to pass a law, a member of the parliament is doing nothing else than expressing its opinion, its political opinion. And this is protected by international law, And I'd like to quote in this regard, to go quickly, Article 19, paragraph 1 of the International Covenant on Civil and Political Rights, which is a covenant very important. It states that, I quote, "Everyone shall have the right to hold opinions without interferences," end quote. And as precised by the Human Rights Committee in 2011, quote, "This is a right to which the covenant permits no exception or restrictions," end quote. So this is a third argument in order to try to prove that there is a rule protecting members of parliaments in international law. Now, if we want to go a little bit further on another argument, we could shift to another approach, which is related to sovereign immunities. So I suppose that everyone knows about sovereign immunities here, but sovereign immunities are made of two kinds of immunities. You have the immunity to jurisdiction. This is not what's interesting us here. And there is the immunity from execution. And obviously, in my view at least, and I can plead that, of course, in my view, the freezing of the assets of a state would be infringing the principle of immunity from execution. And by the same token, if you consider, which is my case, that a member of the parliament acting as such is carrying out his duty as a state agent, it should be protected by the so-called functional immunity from execution that is recognized in international law. Okay, all these are arguments, and you know that arguments become the law if a law says that, or if a judge confirms the accuracy of the argument. So as a conclusion, let me put the question, what possible jurisdiction to deal with these questions, with these arguments? Well, we could have recourse to the International Court of Justice. But well, I think this is not something really easy for Russia, because Russia does not recognize the jurisdiction of the courts. It could, but I don't think that Russia would like that. The second jurisdiction is the European Court of Justice, of course, and my colleague talked about the different arguments that can be made before the court. I believe that other arguments can be made and can be winning arguments. And finally, I think that our procedures can be brought before domestic tribunals in Switzerland or in any kind of domestic tribunals, because the domestic tribunals have to implement to protect the freedom of opinion, as well as the European Court of Human Rights, that can be seized in case the domestic courts do not do their jobs. So this is my final word for today. Thank you, Mr. Chairman.
Thank you very much. Thank you.
Thank you very much, Professor. I would like to give the floor to Mr. Chizhov, the permanent representative of the Russian Federation to the European Commission in Brussels. Mr. Ambassador, thank you very much. I would like to thank organizers for inviting me and to talk about this relevant issue. I try not to repeat what has been said. I would like to say specifically about the sanction measures with respect to legal and natural persons of Russia. I would like to say that the definition of sanction, which is used in artificial manner, since it would be more correctly to say about the unilateral restrictive measures imposed against Russia, because sanctions, as it was mentioned here, is the prerogative of the Security Council of the United Nations. We can distinguish several types of sanctions: smart sanctions against individuals, specific legal and natural persons, and second, sectoral sanctions, so-called sectoral sanctions, against Russian legal natural persons working in the defense, oil and gas and financial sectors. According to our assessment, these restrictive measures imposed by a group of states, meaning European Union, without any UN resolutions, they are not only unlawful, and this is the infringements upon the national sovereignty, Russian sovereignty, but at the same time they undermine the exclusive prerogative of the Security Council, undermining its authority and undermining the security in the region and the world at large. It's not the invention and something new. I wouldn't like to agree with our previous speaker from the United States that the Western countries imposed for the first time during the World War I. I would like to remind you about Napoleon Wars and the blockade of the European continent. Regarding the European Union, some sanction elements have taken place since its establishment, 1957. The first object of the sanction of the then European Economic Union was the Soviet Union. Because of the events in Poland in 1982, and partial trading embargo was imposed against the Soviet Union. Today, the main problem for the European Union is that these sanctions are regarded as a political tool, which is used more frequently regardless what kind of things they are against of, like terrorism or other means or political things. We also are talking about the attempts to punish Russia for Crimea events, and practically all citizens of Crimean Peninsula are suffering because of these sanctions. So all citizens de facto are prohibited to enter Schengen countries. In the majority cases, they are not given visas to the passports that are issued after 2014. Talking about the sanctions, I would like to say the following. EU imposed sanctions against 150 persons, both Russian citizens and Ukrainian citizens, as well as against 37 legal persons, which include companies from Azovsk liquor plant and resort facilities down to the militia of Donetsk and Lugansk. I also would like to listen the expert opinion on two questions. First of all, we have the doubts in the legal purity regarding the decision of the third countries to join the EU sanctions against Russia. Traditionally, it is proposed that the candidate countries of EU should join these sanctions, as well as focus countries of the Eastern Partnership. What is the legal basis of these actions if EU right, at least with respect to the possibility of introduction sanction, does not apply to these countries? Does it change something if these sanctions would follow the pattern of unilateral sanctions? From a legal point of view, it's also strange the accession of Ukraine to the EU sanction, which applies to its own citizens. It's clear that the Ukrainian authorities limit and freezes their assets in the European Union. Some states, after joining EU sanctions, violate international obligations, and a clear example is the absurd reaction of Norway with respect to the visit of the deputy head of the government of Russia, Mr. Rogozin, to Spitsbergen. According to the Article 3 on Spitsbergen of 1920, the free access of all citizens of this agreement should be observed. And this agreement is the basis of the recognition of the sovereignty over this island. And the practice of appeal of the EU sanction is also doubtful. From a formal point of view, those persons listed in the blacklist can challenge this decision in the European Court, which was done by some Russian banks and Mr. Wettenberg. But the practice...
So such practice leads to abolishing of the decisions, and I would like to give the opinion of former Euro-deputy from Portugal, Paulo Kasaki. Says that EU decisions today remind us of Catholic Inquisition, and just the general reasons are given, and they just have to blindly challenge that. Quite often, when the EU court makes the decision for the plaintiff, as a rule it's because of procedural violations or very shaky evidence, and the Council of the US has the opportunity to change the facts for the better, or leave the plaintiff in the sanctions list, or put this person on the list again, as it recently happened with the Iranian institutions. And the formal foundation is Article 215 of the Lisbon Treaty, which is has the separate Part 4 of Chapter 5, limiting measures. And the Council of the EU has to be governed by Chapter 2. And member countries, they introduced the sanctions not because of the safety and security of their own countries or health of their citizens, but only to reach the goal of integration. And finally, the legal grounds of sanctions decisions is the consolidated decision of the EU countries, which is of political nature, and revision of their decision is not in the jurisdiction of the EU court, and the political reasons always prevail. It's quite clear that in such conditions, anti-Russian sanctions of the EU against specific persons or in general could be prolonged forever without any real reasons, but they could be abolished also with political will. So far, we don't see many indicators of that political will. And if we talk about influence on Russian economy and the economy of the EU countries, of course, sectoral sanctions, limitations are the most influential. Financial restrictions were the most painful. They were introduced on the 1st of August 2014, and in September they were getting much tougher. In the first package, the financial tools that were for the time period of more than 90 days were banned soon. That was just 30 days. Regarding financial restrictions, well, we find a number of a number of exceptions in order to minimize the impact on the EU countries. For example, the subsidiaries of Sberbank and VTB registered in Europe are not under sanctions, and there is a similar approach in energy field, and it's not by chance that I mentioned oil. but not gas. It's quite clear that it's connected with objective needs and interests of the EU market. And the restrictive measures of the EU were also introduced regarding military technologies or dual-use technologies, if to be used for military purposes. And what's interesting, that recently, well, we heard a lot about the fate of Mistral, and at that time, when the sanctions were introduced, it was not banned by the sanctions because of the because the French government insisted, and a lot of businessmen and a number of politicians of the EU they say that the sanctions are quite harmful to the economy of the EU, which suffered from crisis. If you look at the major economy of the EU, Germany, so the export into Russia diminished 18%, and this year 34%, and German experts say that anti-Russian sanctions could cost the country the loss of up to 25,000 jobs. And if this process is going to be ongoing, that's going to be losing 0.5% of the rate of economic growth. The banking circles show that a lot of key EU investments in Russia, and quite often they're serviced by EU banks, and that's quite painful. Just recently, it was mentioned by head of a major Austrian bank, Raiffeisen Bank International. After the sanctions, they have to look at just diminishing their presence in Russia. And the same could be said about quite sensitive issue regarding banning of import into Russia of some foodstuffs. Those measures were quite painful for EU countries such as Lithuania, Greece and Poland. I am talking about 3 countries here, but at the same time it's quite natural that producers in those countries, they're trying to exclude those products out of sanctions regime, although their governments voted for unanimous EU decision. Russian response is such that, alas, WTO norms don't allow it. It's possible to have some alternatives that we work with. And my last phrase, the sanctions of the EU are not the subject of our dialogue with the EU. That was the problem which was created by our partners, and they have to find the solution. The sooner they had sufficient potential of political will, the better for our relations and for their economic systems and the future of Europe as a single body. Thank you. Thank you, Vladimir. Now our time is practically over. I would like to use it so that our distinguished guest, the professor from Hunan University, Zhang Nanyang, could also share his ideas regarding this issue. Thank you.
I'm very pleased to have talk with distinguished panelists, and when I received the invitation from the forum, and I selected this topic because I think it's very interesting, unilateral sanction. And I listened very carefully for the panelists previously. benefits a lot from their presentation. I want to make a couple of points from the perspective of public international law. First, what's the problem for the Russia Federation now? I think due to the Ukraine crisis last year, and the Crimea joined the Russia Federation, and the United States and the EU took the basically economic sanction against Russia. That's the problem. But I think China had also similar problem in 1989. And also, our colleague from the United States and Iran also mentioned something for this sanction in a different period of time. So it's not unique, but I think the situation may be case by case. In China in 1989, may you know the Tiananmen Square, due to the political turmoil. And then after that, the United States took the economic sanction against China, and in the year 1989, and the foreign direct investment was reduced 75%. And also for the after that, in the 1919, and for the foreign trade, the volume also increased only 3%. So that means the economic sanction unilaterally against China at that time had a very negative economic impact. And the same in Russia. And essentially, it is the economic warfare between the West Bloc and the Russian Federation. And you can take the picture, Obama and Putin. So it's a very interesting picture. And also the Russian GDP also increased virtually 0%, 0.2. So it's a very significant negative economic impacts. That's the problem. That's the problem. And the second point I want to make, what are the legal issues? Because I'm a law professor and teaching public international law for decades at our university. And I think prevents the panelists mentioned the United Nations Charter, and also my colleague from the France mentioned the general principle recognized by the all the nation, actually civilized the people say that should not added. Anyway, general principle, I think on the United Nations Charter, the general principle, Article 2, provides that to develop the friendly relation among the nations based on the respect for the principle of the equal rights and the self-determination of people, and take other appropriate measures to strengthen universal peace. That's the unilateral. So I think that's the general principle on the United Nations Charter for the multilateral, not the unilateral. Not the unilateral. That's the legal issue on the Charter. Of course, there are different approaches towards the unilateral sanction, because prevents the panelists they made an excellent contribution for the notion of the unilateralism. But I think for the unilateralism, basically is taking in accordance with the national policy. United States or maybe regional European Union, not on the United Nations, the Charter. I think that's for the legal issues. In this regard, I must say that from the public international law, unilateral, economically or maybe politically sanction has no legal basis. I do not want to extend my argument. I think for the distinct audience in this room understand that. Third one, what's the solution? We are talking, discussing, but the goal, we should find some solutions. But I'm wondering what's the solution for now for the Russian Federation, for the international community. And the previous panelist mentioned the WTO. I'm the list panelist. And may WTO provide something model. And you know that the TFEU provided the authorized sanction, not a unilateral sanction. For the case, for example, U.S. Trade Act, Section 301, the big case, and it makes it very clear. No unilateral sanction is permitted. That's the rule of WTO law. No violation so far in WTO. But the question is whether we can copy WTO model for the Russia case. I don't think so. That means it's a difficulty to make a WTO model within the United Nations framework. It's different. And some panelists mentioned that it's politically, yes, it's impossible to separate the politics and the law. For the WTO is WTO. For the United Nations, I think maybe we can consider some solution. I provide global multilateral governance for the WTO, but maybe it's not possible to make copy. But for the United Nations, I have published article and writing my book, contributing ideas called a Triangle Council, because we have the Security Council, but the Security Council has the veto mechanism. And for the permanent member, the United States, China, UK, France, the Russian Federation, so respect has the veto power. So is it possible for the Russia case go to the Security Council? Apparently impossible. United States may be veto, right? And then we consider the Council social and economic culture, but it's promote the economic cooperation, not address anything about unilateral economic sanctions. So it's not an approach go to the Council. And then we have the new Council for the Human Rights, 2006. We have the new Council, Human Rights. But the Human Rights Council now is new and waiting for the review 2021. Maybe become the major organ with the Security Council and the Council for Social and Economic Culture. But currently, it's not. So apparently, it seems to me, it's also difficulty to using the Human Rights Council. So what's the solution? So far, no solution, at least for me. Thank you very much.
We are almost through. We have about 10, maybe 15 minutes before we'll have to leave this room. I would like to, before our guests ask questions, if any questions are left. I would like to finish this part by the quote of a well-known professor of international law with a very strange fate. He was born in Ukraine. He studied in Lvov University. He studied international law, was an Austrian citizen. Then he became a world-famous Cambridge University professor. And I'm talking about Gersh Waterpracht. In 1933, he said the following:
and which has not reached the stage of moral perfection, pacific means of pressure unavoidable. Мне кажется, что эта фраза, она сохраняет актуальность, хотя прошло почти, скоро будет 100 лет.
Well, this phrase is quite topical, and if there are any questions, we'll be happy to answer your questions. But I would like to ask, do we have the microphones for the questions? Yes? Okay, so questions. Raise your hand and ask questions. Michael Swainston, Queen's Counsel, Brixton Chambers.
Question for my colleague, Richard Blakely. Richard explained that there have been attempts at substantive challenges to sanctions on the basis that they violate fundamental rights, rights to property, family, livelihood, and so on. But he explained that they've failed in the European Court because that court defers to European foreign policy. Would he agree that similar challenges could also be brought in Strasbourg under the European Convention on Human Rights, and that the Strasbourg court, with a broader constituency, is less likely to defer to European foreign policy?
Thank you, Michael. Yes, I think that's absolutely right in terms of its substance. The Strasbourg court is more likely to reach a rights-centered and rights-favorable answer to these sorts of questions. It's also far less likely to give the degree of deference to foreign policy decisions that the EU courts have done. There are procedural difficulties and procedural implications about proceeding in Strasbourg, partly because you need a contracting party defendant. And as we know, the EU has not acceded to the European Convention on Human Rights, and the court, it's really the court itself that is the block there, because it wants to be, the EU court wants to be the top tribunal for human rights within the EU system. So there are procedural problems which may be circumvented, but on the substantive question, yes, I think Strasbourg is likely to provide a better route for frustrated applicants in the EU system. The only final point I'll make on that is that you have to exhaust your local remedies if you want to go in Strasbourg. So you may be required to go through the EU system first, making a lengthy process even lengthier.
So a follow-up. Could one not sue member states of the European Union who implement unlawful sanctions in their courts and then in Strasbourg?
Yes, you could, and you would have the possibility, I suppose, of joining all member states as defendant parties in Strasbourg. In terms of in domestic courts, there's currently an action being brought by the Iranian bank Malat in the United Kingdom for damages in respect of the UK's even more unilateral sanctions. It acted before the EU did in respect of certain Iranian banks. The UK courts have found that unilateral action to be discriminatory, and Malat is now seeking damages. That's ongoing, and a decision is not expected for a while, but it's had some preliminary success.
Пожалуйста, еще вопросы, если есть.
More questions, if any? Alexei Dronov, Deputy Head of the Legal Department of the FMA of Russia. I have a question to our foreign colleagues, distinguished foreign colleagues. It's a specific question. It was mentioned that you have to exhaust your national remedies to get to the European Court. I'd like to ask, what kind of exhaustion you can talk here if practically all the decisions that provide for the sanctions exclude the possibility of appeal and challenge? Those are the American president's decisions and the decisions made by European bodies. And are there any grounds to believe that we're dealing with a classic case of denying justice, which is quite a logical continuation of the absurd, from the legal point of view, practice? We have the position on this. Well, we believe that those sanctions are, from the legal point of view, void because there are no grounds to introduce them. And it was mentioned here that a number of organizations were victims of those repressions, but they're not part of the Russian government system, and they are economic entities, independent economic entities. My question is, are we going to abolish the legal approach altogether? Because if we apply laws, we cannot look at different subjects as just one person who is liable for something that we believe could be considered illegal. So I would like to hear the comments regarding that, because a lot is mentioned today, a lot of discussions, but at the same time, how to put it, it's unprecedented, and there are reasons to believe that it's not a legal issue. Those are just repressive and discriminative measures that disrupt existing world order, not just UN-based, but in general. I would like to get the answer to that question in principle. Are you asking anybody specifically, or should we choose? Okay, I hear you.
As far as the European Union is concerned, I don't agree at all with what you mean. I'm very proud of the European Union, because in the Union you can claim before a court that the sanctions should be annulled. You can do that. It's possible. And sometimes when the judges consider that the country did not respect human rights or procedural aspect of human rights, the judges annul the decision. I'm very proud of that. So you cannot say that it's not possible to obtain justice before the European Union institutions. Now, if the arguments are wrong, the judge will reject it. I think it's the rule of law that is applied. Thank you.
Спасибо.
Thank you. Thank you. My name is Anton Petrov. I'm a practicing lawyer. My question is to Konstantin Dolgov first, and then the Russian colleagues. We're talking about the law at the time of changes, and there are some opportunities to challenge sanctions, and for example, regarding damages from the part of European states. Why don't Russian authorities look at the possibility of challenging such actions of European countries in the UN International Court? And there is, I haven't found one single case where Russian Federation tried to be a plaintiff. Nevertheless, the Russian Federation could be a plaintiff. And also I wanted to note that a violation of Ukrainian citizens, they cannot be educated in Russian, and it was not examined in any court. For example, European Court of Human Rights. Why not file such lawsuits? Why not get the appropriate rulings and influence international law? Well, I don't claim to know legal aspects profoundly, and we're talking about the court that deals with disputes between the countries, and when it's trade, let's talk about international commercial arbitration.
And my colleagues, lawyers, professional lawyers, they have maybe better understanding, but as far as the mechanism is concerned, Vladimir Alexeyevich said that we are not engaged in the dialogue on the sanctions. That's our position of principle. And Russia has taken a number of countermeasures in retaliation, and they are different from restrictive measures. It was mentioned here the act of aggression. It is a very interesting topic for discussion. We can look at the Article 51 of the Charter, which is the right to self-defense. But it is very interesting. Of course, we are taking countermeasures of economic nature, and we try to justify them, and we also have taken respective measures to prohibit the access or entry into Russia for certain foreign citizens. We wouldn't like to make this list of individuals public. We are not trying to be drawn into the polemics. As far as your second question is concerned, it is a very interesting question. We have claims to the European Court from the Ukrainian citizens. There are some of them, not many, but some of them with respect to the violation of their rights by the Ukrainian authorities. That could be a motivation why Verkhovная Rada has made a decision which in fact prevents the possibility for those living in Donbass to appeal to the European Court of Human Rights, because they are not happy to see the growing number of appeals or claims that are made on a daily basis. So as far as the Russian Federation is concerned, we are not interfering with the Ukrainian conflict. We have said this on many occasions. These issues should be dealt with by Ukrainian citizens only. Only in the Ukrainian jurisdiction, in the context of the Minsk agreement. I wouldn't like to dwell on the Minsk agreement. Everyone knows better. And this is our principled position. We don't see any grounds and we don't see any need to interfere with this conflict, but we need to try to draw the attention of the international community. No one mentioned about the OSCE so far, and still within the OSCE framework and within the Council of Europe and the United Nations, we always will try to draw the attention of the international community to these issues. We have also the Commissioner Tors representing Finland, which deals with the minority rights. She spared the lion's share of her time trying to find the violation of human rights in the Russian Crimea. I would suggest that she better turn her attention to the serious violations in Ukraine regarding the use of Russian language and violation of human rights during the hostilities and so on and so forth. And we will always try to draw the attention of the international community to these facts. And we have some nuances, of course, here from a legal point of view, but we always should take them into account. Thank you very much. We just ran out of the time. So the last two questions, and I understand the people who are hungry and they just waiting for the end of this meeting. Maybe it would be the violation of human rights as well. So just two questions and that's it. Maybe not. Okay, that's better. If not, thank you very much. Thank you for coming, for participating. Thank you very much, all the presenters.